Morning. This is Aaron Hall. We are here today for a live Q&A session. I'm an attorney for business owners and entrepreneurial companies, but today I'm sitting here as an educator, providing general education on this YouTube channel. Why do I mention that? Because it's important that you consider today's information as educational, ideas to help empower you in your business and in your life, ideas to discuss with your attorney before you rely on them. And uh, it's important to know that I am not your attorney, which means that I'm not giving you advice for your particular situation. Why does this matter? Because an attorney who represents you can take the time to ask you questions, can take the time to understand your circumstances, and can explain the law in your particular jurisdiction, state, county, country, etc. All right, it looks like we have Christopher Levinson saying hello from Los Angeles. Good morning, Christopher. Great to have you here. So please keep in mind, this is an educational channel. It's not an attorney or a replacement for an attorney, even though I am a licensed attorney. The purpose of this channel is to empower you as a business owner in your company and your life. We focus a lot on the law and a lot on business. And I have a whole lineup of great questions today. But as always, if you are watching this live, your questions come first. So I've got a number of questions that came in ahead of time, but I will take the time to answer your questions first if you are submitting them today live on our Q&A. Dan, hello from Seattle. Great to have you here. Thank you for joining live. If you are here today, it's probably because you got a notification. And for those who are watching this later and would like to receive notifications, the best way to get those is by email. Just go to aaronhall.com/free. You'll get onto the free email list. You'll get notified about upcoming live Q&A sessions, as well as access to exclusive video educational content designed for business owners to help you avoid common problems. So aaronhall.com/free is where you can get that. You can also follow us on YouTube and you'll get a notification there. Please keep in mind if you're asking a question that YouTube is public. Everything you post here is on the internet, perhaps forever. So please avoid putting any confidential information out here, any information that you wouldn't want somebody else to know. For example, if you're asking about a situation and your ex-spouse is on the other side, obviously you wouldn't put any information on here that you wouldn't want your ex-spouse to know about. Likewise, don't ask questions about a pending lawsuit. Those are great questions for your attorney in the privacy and confidentiality that's provided with attorney-client privilege. Nothing said here today is confidential, and I'm answering these questions within the context of an educational YouTube channel, kind of like a professor would in a law school classroom. All right, let's get into the topics for today. Here's a question that I was asked recently by a business owner. Is stress good or bad for business owners? The business owner was experiencing severe stress and was saying, you know what, I'm not sure if this is healthy. On one hand, stress motivates. Stress causes our body to take action, and I get a lot more done. On the other hand, we know that stress can be toxic. Stress can disable us. Stress can cause us to perform worse than normal. So, what is the answer to whether stress is good or bad for business owners? Well, I was at the health club this morning, working out and lifting some weights, pondering this question. I thought to myself about how if you don't have any weight that you're lifting, you have no resistance, in other words, you're not going to be building significant muscle. But on the other hand, if you have too much weight, it can crush you, or you may not be able to lift it, or it can cause some sort of injury. And I think that that's a great analogy for the amount of stress in business. Ideally, we want some stress, some resistance, some challenges. That's what makes life interesting. And that means we are not just sitting in our comfort zone, but we're going outside our comfort zone, taking on new challenges, growing our muscle as business owners. And I think that's really important. But on the other hand, if the stress is too much, for example, if you're getting hit by a lawsuit and financial problems and marital problems, etc., that can be devastating. It can be very difficult to know how to navigate uh, too much stress. So, just like a person who spends their life relaxed on a couch is going to find their body becomes weak, their muscles are not being built. Likewise, a business owner who's not putting herself out to accept new challenges or putting himself out to take on new opportunities and stretch themselves outside their comfort zone. We don't build muscle and capabilities unless we have some stress, but too much stress is not good. Just like with a weightlifter. Also like a weightlifter, we need rest. We need time for recovery and recuperation and healing. I'm reminded of an incredible book called The Obstacle is the Way by Ryan Holiday. This book talks about some of these Stoic philosophies. And in particular, it's based on a quote by Marcus Aurelius. If you ever saw the movie Gladiator, which came out probably a decade ago, it featured a character based on Marcus Aurelius, named Marcus Aurelius. The movie Gladiator did not get into Marcus Aurelius's philosophy as a Stoic, but the book, The Obstacle is the Way by Ryan Holiday does. And it's based on this idea that sometimes when there is an obstacle in our way, the way is not to go around it, but it is somehow dealing with that obstacle that allows us to get along our way and get to the goals we're trying to accomplish. I remember one time when I was facing a very significant financial obligation. And I ran the numbers and I realized there was no way for my business to survive if we kept doing things the way we were. We had a runtime of 2.5 months left. And at that point, we would be out of money and wouldn't have the credit to pay bills and keep surviving. Rather than continuing to do things the same way and trying to avoid the obstacle, we had to figure out, how do we press through this? And it was a few days of brainstorming and trying to think outside the box, thinking with how can we get through this particular dilemma? The short version is we had to make a lot of money in a short period of time. So what we did is we dramatically changed how we were operating with a different focus on sales and marketing so that we could fill the pipeline and would generate enough revenue to achieve those goals. Well, once we did that, it's kind of irrelevant how we did it because it's not applicable necessarily to every business owner out there. But it was that obstacle that drove us to change our business model. And as a result, the business started generating substantially more revenue, not just for that couple months, but every month in advance. And from that moment forward, we essentially had an epiphany that brought substantial success and profits to the business. If it weren't for that obstacle, we never would have come across the different business model that we needed to adopt. So sometimes these pressures, these challenges, these obstacles are exactly what we need to grow to a whole new level. So, is stress good or bad for business owners? In short, a little bit of stress is good. A little bit of resistance is good, but we don't want it so much that it kills us. Like the old saying goes, if it doesn't kill you, it makes you stronger. And I think there is some truth to that. All right, let's take a look at the next question here. Dan says Gladiator released in 2000. Thank you. All right, it's been a lot more than a decade. I guess we were at 23 years ago. I'm showing my age. It is certainly one of my favorite movies, along with Braveheart and various other kind of action movies. All right, next question. How do you get over public speaking nervousness? And this is a question for beginners. You know, I'll never forget one of my more embarrassing moments in life. I was a senior in high school, and I was participating in a YMCA program called Youth in Government. This was an opportunity for me as a 17 or 18-year-old to be able to go to the Minnesota State Capitol and sit in the House of Representatives chambers. And each one of us represented or played the role of a state representative. In advance of this legislative session or this mock session, we drafted our own bill and got some co-authors, and it was basically an opportunity for high school students to participate in the government process of making legislation. It was a fantastic experience. I've encouraged my daughters to consider it, especially for anyone who has an interest in politics, government, law. What a wonderful experience it was. In fact, it was so great that I came back later and served as an advisor at Youth in Government. But I'll never forget this one day when it was my job to introduce my bill. I stood up in the Minnesota House of Representative chambers, and I looked around the room, and I knew all about my bill. I had spent hours talking about it. But at that moment, I froze. I remember thinking, I don't have the words to say, and all I could do was look around at all the different eyes looking at me, and I simply did not know what to say. I think I gently mumbled something like, my bill is about blank. You know, I think it was a civil rights topic. My bill is about civil rights and ensuring equal rights for all, etc. And kind of stumbled through the general topic. I did a terrible job. And in fact, it was so bad that one of the co-authors who was sitting next to me, another high schooler, came up to the microphone for me and then saved the day by explaining further what the bill was about. But I'll never forget how I just froze. And it was at that moment I realized public speaking is a skill that is developed. It's not something people naturally have. In fact, studies have shown that the people who think they're great public speakers often are oblivious, and they can actually be the worst. But it's the public speakers who take serious the nervousness and the difficulty of speaking in public and they want to be interesting to the listeners. It's those people who often do best. But here's what I learned after that incident. I needed to figure out how to become a good public speaker. I got a book by Dale Carnegie that helped with it a little bit. But back then we didn't have the internet, so I had to go to, this is about 1993. I had to go to the library, and I went to the Dakota County Library and spoke with the librarian. And I said, I need to learn about public speaking. What do you recommend? And she said, oh, you know what? There's a local group called Toastmasters that you can join. And she said, I'll give you the information there. Back in that day, every librarian or library kept a record of the local community groups and with contact information. So I reached out to Toastmasters. I was the youngest one there, but it was a bunch of people who just met on a regular basis to try to get better at public speaking. And one important requirement in Toastmasters, I shouldn't say requirement, but encouragement, is to speak at every meeting. You don't have to say much. You might just say your name, or you might give a little 30 to 60-second comment on something, and they'd throw you softball questions that would make it very easy. And here's what I learned. The only way I could get comfortable with public speaking and overcome the nervousness was through practice. Through doing it so many times that the brain reworks its wiring, and you start to realize, or you start to develop the habits and the routines in your brain on how to do it. Now, I still get nervous. I actually think that that's great because it heightens the energy within the body. It helps the brain become more in tune with what it's going to say. But through practice, you learn not to fill the blank space with ums and ahs. And you might practice having some pauses, some moments of silence that then emphasize whatever you are about to say. And there are other techniques that you can learn, but the beginning skill is just getting up there and doing it in practice. And so my encouragement to anybody who's looking at improving in public speaking is find an opportunity to speak as much as possible with as low of stakes as possible, because practice is what allows you to build the skills needed. There is no way to really cut corners in this that I've found. There are plenty of skills that can be developed, but it all starts with practice, and then those skills build on that. All right, let's take a look at the next question here. Dan says, slam a beer prior to public speaking. That certainly would cause you to feel relaxed. It may affect, I suppose, the quality of the speaking. All right. Next question here. If you owe money, can they take your bank funds before a lawsuit? So if you owe money to someone, can they take your bank funds? How does garnishment work for beginners? Imagine you owe a significant amount of money. Let's say it's hundreds of thousands of dollars. And you are wondering, what is their right to just reach into your bank account and garnish your money, or levy your funds, or seize your bank account? Well, here's the general rule. Generally speaking, nobody can touch your property, including bank accounts, home, vehicles, etc., unless they win a judgment against you. That's first. Second, they have a lien on the property that you granted to them by a contract. And typically that has to be filed with the state under UCC Article 9. Or third, they go to a court and get what's called a pre-judgment lien or right to garnish. And usually, the only way a court will grant that is if there is a serious threat that you are going to move those assets to a place where the creditor cannot get them if the creditor wins against you in a lawsuit. So let's play this out. You owe somebody hundreds of thousands of dollars. Now, and if you gave them a UCC lien on your assets, then they would have whatever rights are established in that lien. So that's the first thing to take a look at. Next, they would have to sue you typically in order to take any of your assets, assuming there's no lien. And in rare circumstances, a creditor can get a prejudgment garnishment, levy, or freeze on assets. What's an example of when that might occur? Well, let's say you have some Bitcoin in a Coinbase account or a Binance account, and there is a risk that you would sell that or move it into a hard wallet, basically moving it off the internet so that that person couldn't later garnish that. Or let's say you had money in an account and there was a threat that you were going to wire that money to an offshore account that US jurisdiction wouldn't have authority over. Or let's say you were looking at paying that money to somebody. A creditor in those situations has a couple rights. First, the creditor has a right to ask the court to freeze those funds. The other option is what's called an involuntary bankruptcy. Instead of going to a state court where a lawsuit would be commenced and the creditor asks for your funds to be frozen, a creditor can file in bankruptcy court for an involuntary bankruptcy. And by doing that, the creditor has the full strength of the bankruptcy code, empowering the trustee who works for the court to manage the assets and protect and preserve the assets so that it can't be transferred away. So let's go back to the original question. If you owe money, can they take your bank funds before a lawsuit? The general rule is no. They'd have to actually get a court order to do so. But after action is filed in court, state court as well as bankruptcy court does have the authority to order the bank or other institution holding the funds to not transfer those funds away or freeze them, essentially. All right, let's talk about the next question here. What is premises liability? Premises liability is when you own property or a premises, or you manage property. So we're talking about real estate here. It might be a home, it might be commercial real estate like an office building or a factory. It could be a farm, or maybe you just own land. It really doesn't matter. The doctrine of premises liability applies. And that doctrine says that you can be liable in some circumstances for what happens on your premises. Premises liability is a form of negligence law. What is negligence? Well, negligence has four elements. You have a duty to act as a reasonable person would. You've breached that duty by your conduct. Your breach was caused some sort of injury, and that cause was foreseeable by you or should have been foreseeable by you, and their actual harm or damages or injury. So essentially those four elements: duty, breach, causation, harm, or injury. So imagine you own some property, and let's say that you put out on on the property, or you leave out on the property some rusty old equipment that looks like a really fun thing for kids who are walking by to play on, but it's sharp and it's rusty and it's dangerous and it could break at any time. Imagine now that one of those children come up and climb, the child climbs on the equipment. Are you liable under the doctrine of premises liability? Well, let's go through the analysis. You have a duty. You have a duty to keep your equipment that's on your property safe from people who would be trespassing from you. And then, if so, did you do it? And then, obviously, in this case, the equipment caused the injury. So here in this case, it illustrates the whole question of, well, what if somebody's on your different categories of people on your property? What if somebody's coming on your property to steal from you? They sneak in the night. They're armed. They're coming there for the purpose of stealing from you. Or maybe it's a guest of yours. You have a home and you had some people over to enjoy a nice afternoon, and the kids are playing in the backyard. Or maybe it's a business and customers are coming to the business. As you can see, there are different categories here. The doctrine of premises liability looks at those four categories. So what are they? An invitee. This is a person who you've invited to come on the property for a business or commercial purpose. Second, a licensee. This is a person you've invited to come onto the property for a social purpose, or they're there for a permitted purpose. Third, you have trespassers, people who are not permitted on the property but are there anyway, illegally. And then fourth, children. Children who might be trespassing. The short answer here is that you have different levels of duties to each category. You have the highest duty to a person you've invited on the property for commercial purposes. You have a lower duty for people who are there for social purposes because you have no financial benefit of having them there. And you have the lowest duty to a trespasser, but you still have some. And then in some jurisdictions, even though children may be trespassing, if you create an environment that's attractive to them, it's called an attractive nuisance. If you do that, you will likely have liability in those jurisdictions. So every state has different laws on this. This is generally what's called common law. In other words, it's not necessarily laid out in detail in the statutes. It is decided by judges over the years, and they have refined this doctrine. And then each state's appellate court or Supreme Court has determined what will be binding law in that particular state. So just keep this in mind. You do have a duty to avoid dangerous situations for people. So being negligent about leaving sharp objects in a yard, slip and falls can be negligence. Now, in Minnesota, we have ice all the time. So there's an assumption in Minnesota that during the winter, sidewalks can be slippery, especially after a snowstorm. But perhaps after a reasonable period of time, a person could expect that a sidewalk will generally be safer. It will be shoveled, but not right away after a storm, and not after a rain that freezes. Inside a store, if there's a puddle of water leaking from a roof, if the store doesn't know about it, none of the employees know about it, they may not have any liability yet. But as soon as they know about it or should know about it, they should be mopping it up or putting up a sign. That's where a slip and fall case can come into play. These are generalities. Every state is different. But that is the doctrine of premises liability. There are a couple other things you should know. As a practical matter, You can generally get insurance to protect yourself from premises liability. That's a great option. It's really important if you have people regularly coming onto the premises. The second thing to keep in mind is that in Minnesota and many other states, we have a law called social host liability. This is kind of related, so I'll mention it. Imagine you have a little party, you don't have a bartender there, but people are drinking, and then they drive home intoxicated and they hurt themselves or others. Under Minnesota statute, you can have liability for the injury they caused because they got intoxicated while you were hosting them socially. Now, if, as a general rule, if a licensed bartender is present, then the bartender doesn't have liability and you don't have liability. But there can be some gray areas in this area of law. All right, that's a summary of premises liability for beginners. This is a topic that's regularly covered in law school. But then once you become an attorney, you either specialize in this or you ignore it. And I personally do not work with premises liability, but I learned it in law school and I occasionally see it in a number of cases that I work. Okay. This question has multiple parts here. I want to pass my life insurance, retirement plan, and assets to my children after I die. One of my children has disabilities. How does all this work? What should I discuss with my attorney? Well, this is a great example of a lot of issues that overlap, and so it's important to discuss this with an attorney. But since this is a general educational channel, let me explain how this works. Another way to answer this or ask this question is, what are creative ways to give away stuff when you die? Well, let's first talk about life insurance. When a person passes away, if they have a life insurance policy, that policy is immediately paid to the beneficiary that's named on the policy. A beneficiary is just a person who benefits from the policy. That money does not go through a will. That money does not go through a trust. A life insurance policy is immediately paid to whoever is listed as the beneficiary. If that person doesn't exist any longer because they've passed away before the policy was, before your death and the payout was needed, then either the insurance policy goes to the next named beneficiary, what's called a contingent beneficiary or secondary beneficiary. And if there is none, or if that person has passed away, then the life insurance policy goes to the estate of the person who passed. And that estate then is handled either by a will or a trust. You might be wondering, can you name a trust as a beneficiary on a life insurance policy? Yes, you can. The trust can be the entire beneficiary, or the trust could get half the proceeds and the other half go to a spouse or somebody else. So there are a lot of options as far as who gets the life insurance policy, but just keep in mind, what's on the policy is what matters. Any other documents are irrelevant. The money, the beneficiary named on the policy is who gets it. Now, if you have the beneficiary named as your trust or your estate, then of course it would go through those processes. How do you give a retirement plan when you die? A retirement plan has a named beneficiary. In other words, when you set up a retirement plan, there is a person named as the beneficiary of that account. It's essentially a bank account or an account with a financial institution. Whoever is named as the beneficiary gets that money. Can you name a trust as the beneficiary? You absolutely can. So the retirement account does not pass through a will and does not pass through a trust unless the trust is named, of course. A retirement account goes immediately to, on the day of death, the person who is named as the beneficiary. Can you have multiple people named as a beneficiary? Sure. You could say, to my 4 children, 1/4 each, or 25% each. You could say 50% to my spouse, if I'm married at the time, and the remainder divided equally among my children who are then living. And if any of them predecease me, my child's share, who predeceased me, will go to my child's descendants. There are a lot of different ways to write this up. Now you might be wondering, how do you write all that on a little beneficiary line on a retirement account? Often you can't. Often you have to keep it really simple. And if you want to get complex, you may need to make your trust the beneficiary and then put all those instructions in the trust. How do you give real estate when you die? There are a few different ways to transfer real estate when you die. First, many states allow you to use what's called a transfer on death deed. The acronym is TODD, sometimes called a TOD. A transfer on death deed is a document that you sign prior to your passing and file with the county recorder's office or whatever is the appropriate process in your state. And upon your passing, the property immediately goes to whoever you named as the beneficiary. So it might be your spouse or your children. What's really important about this is the property bypasses probate. It bypasses anything in your will. So you can have a transfer on death deed avoid your home going through probate. That's one option. The second way to make sure real estate gets to the person you want to get it upon your passing is to use a will or to not have any estate plan at all. Whether you have a will or no estate plan at all, it will go into probate. Probate is a legal process where the court looks at the statute and at the will and determines who should get your stuff. If you have a will, the court follows the will, assuming it's valid and binding. If you don't have a will, then the court looks at the statute, and the statute has default rules about how assets are divided or distributed among your next of kin. The final option for transferring your real estate is through a trust. The important thing about this is you need to set up the trust before you pass, of course, and you need to transfer the real estate into the trust. Once you've done that, that real estate is no longer part of your estate. It's no longer governed by your will. Everything in the trust is governed by the trust. And you can appoint somebody who manages the trust. The name for that is trustee. And that trusted person, that person who you are relying on, will execute the instructions you've provided in the trust agreement. So, what are the 3 ways to transfer real estate after your passing? You can either do it through a transfer on death deed, a will, or no estate plan at all, which either way will send it through a probate in the court, or through a trust. So, transfer on death deed, probate, or trust. How do you give a vehicle when you die? This is very similar to real estate in Minnesota. You can essentially file a document with the state government, the department that handles motor vehicles and licensing and registration. You can file a document that says, upon my passing, this person should get the vehicle. You name them as a beneficiary. That's on file with the state, and then upon your passing, the person who is the beneficiary can simply go to the state with your death certificate and the state will transfer ownership to you. That's option number one. Option number two, you can have it handled through probate. So if you don't have a will, or if you have a will, either way, it goes through probate. By the way, probate is not avoided by a will. Put another way, a will never avoids probate. A will is the instructions for the judge in a probate. So whether you have a will or none at all, that vehicle will go through probate and a judge will decide who gets it. And then finally, you could put that vehicle in a trust. And it's important to make sure you actually transfer title of that vehicle into the trust in order for the trustee, that's the person you designate to manage your trust, to have authority to take care of that after your passing. How do you care for a disabled child after you die? There are a couple options. If this person is so disabled that they're not able to care for their own affairs, then typically a custodian and or guardian will be appointed by a court to represent them and to care for them. You can allocate money in a will that goes to that disabled child's personal assets. So it goes to the child. But if they can't handle their own assets, then the custodian or the guardian would be making decisions regarding those assets. Usually the better approach is the second option, which is a trust. In fact, it's often people use a specific type of trust called a special needs trust or a supplemental needs trust. These options, which go by different names in different states, allow for somebody appointed by you to care for the needs of a loved one who has special needs or disabilities under law. And this can be during your life and it can be afterwards. So if you have somebody, a loved one with disabilities who you would like to have your assets used to care for them, then I would encourage you to work with an attorney who is used to setting up and has experience setting up a trust for special needs individuals. All right, so let's go back to the big question here. What are creative ways to give away your stuff after you pass? Well, if you do a little planning in advance, often you can name a beneficiary for your property so that whether it's a home or a vehicle or another type of property, like a bank account, that can immediately transfer and not go through a will or a trust. The second option is a trust, but you need to make sure you transfer the assets into the trust before you pass. And the third option is a will or not having a will. And either way, it goes through probate and a judge decides. There might be one other option, and that's just simply give it to the person ahead of time. In fact, that's something more and more people are doing, because instead of waiting for that gift to be a blessing on that person's life after you pass, many people are choosing to give the gift during their life. The benefit of that is you get to enjoy the rewards of giving, and you get to see how your gift benefited the life of your loved one. All right, let's take a look at the next question here. Okay. Before I get sued, can I transfer all my assets to a trust? So here's the setup. Imagine you realize there's a good chance you're going to get sued. Let's assume it's for a specific situation. Do you have the right to transfer all of your assets into a trust at that time? And if you do, will that protect you? And in particular, will it protect the assets that you've transferred into the trust? So let's say, for example, you have a cabin, a home, shares in a business that you own and operate, and some expensive vehicles. Can you transfer all of those into a trust so that if you get sued and lose in court, you don't have any money? Everything's in the trust. And so you might even be able to file for bankruptcy and everything is protected in the trust. Will that work? No, it won't. It won't work for a variety of reasons, and I'll explain what those reasons are. So first off, the most common type of trust used for estate planning is a revocable trust. That's a trust that you can revoke or change. You can put stuff in and pull it out, etc. That's not going to work because whatever you have a right to in a lawsuit, your creditor would have a right to. So if you have a right to pull stuff out of a trust, the creditor has a right to that. So that's not going to work. But what about an irrevocable trust? An irrevocable trust can protect your assets from creditors in certain circumstances, but it's not going to work here. First, what is an irrevocable trust? An irrevocable trust is a trust that you set up and you cannot change it. You cannot revoke it. You cannot modify it after you've set it up. So sometimes, though, people will name themselves as a trustee, so they get to manage that trust. Or they'll name themselves as a beneficiary, which means they can benefit from the assets of the trust. So why doesn't this work? Well, first, if you want to continue to use your business and your home and your vehicles, you're going to need to be a beneficiary, because a beneficiary is the person who benefits from those assets if you put them into an irrevocable trust. And if you wanted to make decisions about all this stuff, you're probably going to want to be a trustee. Once you are, or if you're a trustee or a beneficiary, the creditor, if the court grants it, has rights to everything you have. So just like a creditor, or you could benefit from driving the vehicle or selling the vehicle, the creditor would have those rights. There is an exception to this, and that's if you use a trust that is in another country that does not honor the orders by United States courts, and you appoint somebody else as the trustee of that trust. But keep in mind, if you are here in the United States, and in that case, the court has jurisdiction over you. So the court can tell you what to do, including holding you in contempt of court if a court believes that you have the ability to make payments to a creditor, but you're not doing it. So it's quite difficult to set up an irrevocable trust that allows you to benefit from some of the assets unless you get sued, in which case some other appointee or trustee appointed by you is handling that and cutting you essentially off from that. You can do it, but there's significant expense. You have to find essentially a law firm in another country who will serve as your trustee. But there are a couple other problems with this. If you set this up at the time that you are aware of a threat and a lawsuit, the court can undo that transaction, essentially disgorge the trust of these assets. If these assets are located in the United States, a court can order the county recorder's office to change title of real estate. The court can order the Department of Motor Vehicles to change title of vehicles. The court can order a bank to transfer money to your creditor. So even though a trust may be outside the jurisdiction of the United States courts, if the assets or the property or you are within the United States, you are susceptible to the jurisdiction and authority of the courts here in the United States. Sure, a trust might make it a little more difficult, but ultimately a court can grant access to a creditor or ownership to a creditor for your stuff that's within the United States jurisdiction. Another problem with transferring assets into a trust at the time you know of a threat is what's called fraudulent transfer laws. If you transfer anything with the intent of preventing a creditor from getting access to it, so you have a known creditor, a known threat, and you transfer it away, under fraudulent transfer statutes, that transaction can be undone by a court. Very similarly, the bankruptcy laws, United States Bankruptcy Code, allow a trustee to undo transactions for the benefit of creditors. So a trustee can retroactively do this. There are a number of online services that sell these international trusts to protect your assets. There's a lot of hype. There's a lot of fear mongering that goes along with that. If you are considering doing something like that, I would recommend you work with an attorney licensed in your state who's representing you, not one of these services, to take a look at the circumstances and determine, does it really protect you in the way that you hope? I'm a bit cynical because I see the hype and the fear mongering from some of these services. And my clients have come to me and said, hey, will this protect us? We need to do this right away. In fact, I've had clients who've already spent the money. And I look at the situation, I go, it's not going to protect you. We have fraudulent transfer laws. We have bankruptcy code. The court already has jurisdiction over you and all the assets that you have. These assets are in the United States. For many, many reasons, you usually cannot transfer assets into a trust and thereby protect them from your creditors. Now, if you do it way in advance, sometimes it can work. It all depends on the circumstances. All right, I'm taking a look at the questions here. Let's do this one. What factors should I consider before selling a business? Usually when I talk with clients, I ask them, why do they want to sell? What normally happens is they want to sell because they're tired of running the business. Obviously, if the business isn't doing well, it's not in a good position to sell. So usually the business is going well, but it's taking a lot of time from the owner. Usually, if the business is doing well and doesn't require much of the owner's time, the owner doesn't want to sell. So what we have here is a perfect or a scenario where the owner is spending a lot of time in the business and wants to be done with it. That actually is not the best time to sell, because once you sell, you don't want to keep working in the business. You want somebody else to take over it and run it and manage it. If it's possible for you to appoint a manager to replace you, then your business will substantially increase in value, because essentially it can run on its own. It's a company that is independent of the owner's active involvement. So if you want to make significant money in a sale price, the best option is to appoint somebody else who can run the company. Now, sometimes that's simply not possible. Sometimes it's a scenario where it's a small business, let's say a bakery, and you're the baker and you need to have some other baker come in because the business isn't generating enough money to afford hiring a baker and then being profitable for an owner. And I get that. That if that's the case, you're not going to be able to sell it for very much because whoever comes in there is taking on all the liability, all the management duties, and needs to be a baker and continue to work every day. And essentially, that person's profit is simply their salary. So that's not a great scenario for getting a good sale price. Often, when I talk with my clients who are looking at selling about how to delegate and elevate, we look at implementing an entrepreneurial operating system like Traction or EOS. Essentially, what that is a system of accountability and reporting and setting up standard processes or best practices throughout the company so that it can largely run without you. And then, second, hiring the right people to run it without you. Once you've accomplished that, the value of the company goes up substantially. But here's something that my clients have experienced. Once they no longer are working a lot in the business because they put together an entrepreneurial operating system and the company starts running without them, they often find they enjoy the business more. They no longer need to sell the business because they already are spending less time in the business. Essentially, they've accomplished what they want of not having to be in the business every day. Often the company is making more money because it has better internal processes and the business owners keep it. But if you do decide to sell, when the company can operate on its own without your involvement, you'll get a lot more money. There are some exceptions to this. One exception is if you are selling to a strategic buyer. Typically, a strategic buyer is somebody who wants your intellectual property or your customer list or something, but they may not necessarily be interested in continuing to run the business as you've done. So, for example, let's say you came up with a really cool piece of software code, which is patented, and Amazon wants to buy that your company so they can get that software code. That's an example of where Amazon may not continue to run your company. They probably won't. They just want that software code to get your patent. So there's an example of where a strategic buyer doesn't care if your company can run on its own because they're not going to keep running your company. Another example of a strategic buyer is if somebody wants your customer list. Maybe you have a great reputation with your customers and clients that you've built over time, and somebody else would like to provide additional offerings to your network, to your customer list. That's a great example of where they may be able to make a lot more money than you were by running the business. They may not even plan to keep running your business, but they plan to market to your customer base, and they'll make substantial revenue. They plan that way. So, what factors should you consider before selling a business? Is the business able to run on its own? If not, do you want to keep the business, or do you want to increase the sale price by working on setting your business up so it can be run on its own and profitable on its own? And if you did do that, would you prefer to just keep the business because now you're putting in much less time? So that conversation helps business owners think about what's motivating the selling and what are they willing to invest in additional work to get their business ready to sell. The takeaway here for younger business owners is to start getting your company so that it can run on its own. Because if you want to sell it someday for a profit, it eventually needs to be able to run without you. All right. Looks like we are at the top of the hour. I'm going to wrap up here. If you'd like to be notified of the next YouTube live that we have, or the next live Q&A, you can go visit aaronhall.com/free, enter your email address, and you'll get access to exclusive educational videos, and you also will get a notice next time we go live. You can also subscribe on YouTube. And if you follow us on other social media platforms, you'll see some of the videos that we put out on those as well. It was great having some time with you today. If you have follow-up questions, feel free to add them into the comment section below or send them by email. We'll do our best to answer those in the next live Q&A. Thanks for joining me today.